record. All right, everybody. Welcome to the Life in Vancouver show. I'm your host, Doug Varenas, realtor and occupational therapist in Vancouver, Washington. And today on the show, I have Nick Alexander. He is an estate attorney with Vancouver Wills and Trusts. And today we're going to go over an overview of wills and trusts and just kind of use it as a jumping off pad for anyone who's interested. So first, Nick, I just wanted to ask you like how you got into this sort of law and kind of what's your general background in this area?
Yeah, nice to talk with you again, Doug. Hello to everybody out there in the internet world. Yeah, so it's kind of a funny story how I got into estate planning. I wasn't, anticipating being an estate planning attorney when I graduated law school. I really didn't know much about it. I knew it was an area of law. I thought it'd be boring. It turns out it's definitely not. But I wanted to be more in courtrooms and kind of, get my hands dirty. So I thought, well, how am I gonna, do that? So when I graduated law school, I, hung up my shingle, being a family law attorney. And you may not know this, but about half of all attorneys out there are family law attorneys, and that's because that's just the most work. There's always going to be repeat, stuff. There people are always getting divorced, and there's always custody issues. So just a vast majority of the attorneys out there are just family law attorneys. So that's kind of, what, well, I guess I'll be join those ranks. So as a family law attorney for about, probably 8, 9, 10 months, I hated it. It was terrible. I was not, enjoying myself. I'd come home just way too stressed out. My, wife and other workers and stuff say, we have to find another way for you to, make a living, because this is, going to kill you. It's gonna, I'm gonna rip out my hair. I just was not enjoying being a family law attorney. I was thinking, like, maybe I should go back to school and not be an attorney at all. Like, what are my options here? And so I started thinking about it. And, another attorney in my office said, you better just like pivot right now. Like, you haven't been in it long enough where if you started, doing another area of law, if you stay in family law, you're going to have what's called a golden handcuff, because there's always going to be referrals. There's going to be people, coming back, and your business is going to grow. And so you're going to be stuck here. They're like, kind of take it from me, like you're going to be stuck here. So, talked with my wife and family, and thought about it. Well, what area law did I not hate? Well, after I did a couple, divorces for some clients, they'd come back to me and said, well, now I need to do a new estate plan, because, I don't want my ex to be, a beneficiary. I don't want, these people in this area of my life anymore. So I said, I can do that. So, we do a new estate plan for them. And I liked it. It was fun for me.
Good, yay!
Yeah. So thinking back, like, well, I did 3 or 4 estate plans for, divorce clients and things like that. I didn't hate that. Maybe that should be the area. And so literally that next Monday, I rebranded. I stopped answering phone calls from all the family law clients. I just sent them out, rebranded, started marketing and, educating myself in a different area of law, and completely made the pivot. And that was about 10 years ago. And since then, I've only done estate work, and I haven't looked back since. So, and it's all I do. Vancouver Wills and Trusts. I can't do divorces. Nobody's coming to me for landlord tenant law, that type of stuff, because I'm very focused in my little corner of the world here.
You hear that, people? Do not try to get him to go back into the courtroom to do that.
There's not
No,
enough money.
it's not going to happen.
Not enough money in the world for me to ever go back into that former life. I am so glad that conversation happened, and I was able to pivot. And I wasn't, like I was saying, like she was saying, stuck with that golden handcuff, because I was early enough in the game to kind of pivot without it being too disruptive.
Right. Well, that's a great thing to be able to find what you're really good at and enjoy, because I imagine it could be really stressful. So for people out there who
everything, so
yeah.
it was a big leap of faith.
So I know a lot of people that have young families, and we're talking like under 6, and they're starting to get some momentum to build some wealth, and I'm sure that they're thinking about, if they haven't done it already, they're thinking about estate planning, or they should be thinking about estate planning. So if I'm thinking about doing a will or a trust, or where does one begin with those, and how does one begin to sort of just start that process of knowing what they need in their estate planning?
Sure, and every one of these conversations, I have to preface, everyone's situation is unique. This is all just kind of
Right.
general information. If I always advise you to go speak with an attorney, kind of address the specific needs. So it's getting that, out of your way. The big difference between a will and a trust is, there's many, and this is a very broad 30,000 foot review. So we're not going to get into the nitty gritty of everything, but the big thing that, I explained to the folks is, probate avoidance is one that, a trust has over a will. And also a trust has a lot more ability to control your assets from the grave, where, you can set certain conditions or tranches of distribution. People tell me all the time, I don't want our little Billy here to get all this money at once. It's gonna, it's gonna be, bad news for them. They're gonna end up in jail. They're gonna, it's gonna get, stolen from them or whatever. And so what we'll say is, okay, well, then you get it, in certain tranches of distributions. You don't get it all at once. It's going to be spread out over time, or they have to be 35 years old, or they have to graduate college, or they have to, pretty much any your wildest imagination can think of having these conditions or restrictions placed on the money. And then finally, there's some estate tax mitigation strategies that we can employ. If your estate is over, it's currently $2.193 million. It's set to go up in a little bit. We'll see if that sticks. And that's an estate tax exemption. So below that amount, there's not going to be any estate tax ramifications anyways. Above that amount, then we definitely want to talk about mitigating some of those taxes so that, obviously it can, go to your beneficiaries instead of going, to the Department of Revenue. That's something we know where we kind of will, dig in and craft a, estate plan that's more custom, if you're above that amount, to help avoid some of those taxes, some of those estate taxes. But, the big thing people often talk to me about is, even if they're below that amount, even if they don't have concerns about, a beneficiary, a child, or somebody else receiving the money at once, they still want to avoid probate, because probate is about a 6 to 8 month long process and about $3,000 to $5,000 or so in attorney's fees. And I'll just briefly explain what probate is. That's where
Sure, that'd be great.
that's where you take your will, and people think, why do I have to go through probate? I have a will. Like, wills equal probate, because it's a title clearing service. The will says who gets what and how to divide it, but it doesn't disassociate your name from your assets. So your home, your car, your bank accounts that don't have beneficiaries, and your personal property, all that. Like, how do we, change legal ownership from you to give it to the beneficiaries? That's what probate does. And it's not a natural thing. Like, Doug, I can't go sell your home. As a realtor, somebody just can't go sell a home that they don't own. It's not a thing. Even if the will says, the home goes to, my son Sally or my daughter Sally, Sally just can't list it and sell it. They need authority from the court. And that's what probate is. And we have to do petitions and orders and waivers and oaths, submit the will to the probate court and do accountings and, put different state agencies on notice, do that real thin thing in the newspaper they've probably seen that says, notice of creditors, the estate of Joe Blow, and blah, 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 blah. So it's like a whole process. And, that's why it costs $3,000 to $5,000. And that's why it takes so long. And a trust avoids all that. So, so maybe a little bit more money up front, but it does avoid probate and does give you some of those other benefits.
It sounds like it's more control. You can sort of target who gets your money when and under what kind of stipulations if you wanted to do that. And that's via trust, correct?
Yeah, trust. Yeah,
Okay.
simple will. If you just want to have it, here you go, and you don't mind going through probate, then yeah, a will is an option for you. But if you want to have a little bit more control and want to avoid probate, and if there's some estate tax concerns that we talk about, then or if you have property in multiple states. So that's the other thing that I like to bring up to folks is, hey, if you have property here and property in Idaho and Oregon and California, wherever, like, you're going to be doing 2 probates here and there. And so, like, just without even, breaking out the calculator, like, I will say, like, it will make financial sense for you to do a trust because, take whatever $3,000 to $5,000 and double it, so because that state has to also go through a probate. So that's,
It can get kind of messy.
It can get messy and it get time consuming. Yeah. It can be, expensive. And so we're just trying to streamline and kind of grease the skid. So, after your passing, it's a lot more of a streamlined, easier process for your
Okay.
family.
Now, I had something that had a will that converts to a trust.
Yeah.
So can you talk a little bit about how that works and what are
It's
the
a hybrid,
advantages of that?
hybrid of the two.
Okay.
It's called the testamentary trust. And so it has, the will component where, you don't have to retitle assets. If you have a trust and you have real property, you'd want to make the trust the owner, and I do that, me and my firm retitle your assets, but your bank accounts and stuff, you make the trust the owner, make the trust the beneficiary. But you don't have to do that with the testamentary trust. It just says, whatever I own, it's going to go under these terms. So it's kind of a hybrid of the two where, yeah, you have the will where it still needs to go through probate, but then you also are adding a component where you get to have a little bit more control from the grave. So, concerns, everyone get in all at once, or you want to have, different benchmarks that your, beneficiary meets first.
Right.
We can put that together, but you don't have the extra cost and hassle of retitling assets. So it's kind of a little bit of, a little bit of both.
Yeah, that's a great point because putting things into the trust now could complicate how you're able to go forward as far as like purchasing other assets or what you can do with those assets if they're under a trust. Is that correct?
Sometimes, almost all the, trust and what I've been talking about today is going to be a revocable trust. So you can absolutely change anything you want all the time. You could sell, you could buy, you could do whatever, because you still retain control over it. Sometimes there's what's called an irrevocable trust, and there's various reasons why we do that. You definitely want to talk with a state professional before you consider that or enter into one. But that's a little bit different where, there's reasons why people do that for Medicaid or for tax mitigation purposes or, whatever it may be.
Sure.
But you lose some of that control, because, you take it out of your estate. But, some of the other advantages, which, if you want to learn more about it, I'd encourage people to reach out to me. We can,
Right.
what's the differences and why it might work or not work for you.
Sure, because it can get pretty complicated.
And
So if I'm,
get
yeah,
extremely complicated extremely quickly. And
yeah.
it's
So
that's why we're here to help you navigate everything.
right. And so if I'm a family and I'm watching this and I'm kind of like, well, I'm interested in getting this process started. I hear sort of the overall differences between a will and a trust. Um, what kind of documents do they need to get together, or what's that process look like from, oh, hey, I need to do some estate planning to, meeting with you? What sort of things would they need to compile?
Well, we do like to get a financial summary together, because it's important to write down where your assets are located. It may surprise you or it may not, but about 25 to $30 billion a year in the United States goes unclaimed, from people passing away and their children, their beneficiaries, not knowing where it's located. And I'd scream this from the top of my, roof if I could, if people, didn't think I was crazy. But write down where your money's located, because, most people, I mean, majority of people I talk to, and I'll ask them, at the end of our consultation, if you were to, get hit by a bus driving home today, would your beneficiaries know where these accounts are? Would they know everything? Would they know where your investments are, your life insurance, your, 401k, if you have a CD somewhere or a, money market or whatever. A vast majority say no, they wouldn't know everything. Maybe they know IQ
Yeah.
credit. They dropped me off there to cash a check one time, so they know I bank there, but they don't know about my life insurance. They don't know about all these other, accounts I have. And I say, well, if they don't know it, they're not going to get it. We don't get, statements in the mail anymore. Back in the day, you just wait a month and then you get a statement from this, investment company, from this life insurance. Okay, well, now I have, Fidelity Life or whatever. I need to go, talk to them. We don't have that anymore. Statements don't come. They maybe get emailed, but guess what? They can't get into your
They
computer.
can't reach your email. Yeah.
They can't read your email, so they don't
Yeah.
know where it is. And so that's why it's incredibly important. And we will, when we make the appointment, we often will email this financial summary. It doesn't talk about, value, and doesn't talk about, all that stuff, until we feel comfortable hiring me. Then we'll kind of dig into it. But we'll talk about it, getting it, ahead of time. But there's really not much people need to bring into the initial consultation, just kind of general ideas of, who do I want to be my guardian of my children, heaven forbid scenario where, my spouse and I pass away before they're 18. Who should be my medical agent? That's going to be through your power of attorney. Who should be my, successor trustee or my executor? Who are these people and under what percentages, do we want to give? So it's kind of like just big picture questions. People, come into my office and they can't even spell trust, type of thing.
Right.
And then, I educate them and say, this is, the type of stuff. And sometimes we do multiple meetings, and that's totally fine because, well, now I know what I have to go start thinking about and what I need to kind of get down. Because sometimes there's not an easy answer to that, but just kind of just general big picture questions of who should be these.
And I do think the hardest part, especially for me, was to write all that information down. And I honestly can't say I've done all of it 100%. So shame on me. But yeah, I know exactly. But that was really the hardest part, is to like track everything down and to document where it is specifically so that my wife can access it, in the event that I pass. So I want to agree with you on that, is like getting all that compiled. And then, having those conversations about like, who's going to take care of my kids if, God forbid, like my wife and I passed away. So, I mean, there is some like kind of tough discussions involved, but I think for those of us who have families and especially younger families where you're starting to think about these things, it's like imperative to get that process started, because you never know. Like,
we're all adults now. We need to start having conversations, and it's one of the things where people don't like to ultimately think of their demise and this type of stuff, but trust me, it's gonna be something like that potentially could be an issue, and it's 1,000 times harder on your family, on your kids, on everybody, if you don't have these conversations and to kind of don't get it at least the system or the process started be
a lot more pain and inconvenience in the future for these kind of things. So trust me, you said, was that pun intended? I would hope.
Yeah.
But yeah, I do think, doing, it's an ounce of prevention, like doing it now and kind of thinking about these things now is going to save the people you love a lot of headaches down the road. Which kind of brings me to the same people who have kids and are thinking about estate planning might have parents who are older and who, may or may not have their financial ducks in a row. How, and maybe this isn't a legal question, but I mean, you deal with people a lot. What's a good way to get that conversation going with older parents to just see like, hey, I hope this never happens, but I know eventually it will. Like, what's the state of your finances, and like, what's that going to look like? And how do you start that conversation?
I often tell people it's great to have these conversations after a nice, like, invite them over, get them so full of like, spaghetti, their favorite meal or whatever, they can barely move. And then start having those conversations, because they'll be disarmed. They'll be more willing. They're sitting at the dinner table already. Then you have those conversations, because it's going to be important. And I just tell people, hey, if you don't write this down, if we don't get this stuff set up now, there's an extremely high chance that it will be not claimed, and then it'll be donated eventually to the state of Washington.
Right.
And it'll be unclaimed property, be abandoned, and they're going to build a traffic light in Kennewick or something like that. Like, rather have your children, your grandchildren have this money to help with college, to help with, a first car or whatever, or a parking lot,
to be the traffic light.
The traffic light, exactly.
It won't even have your name on it. They'll just build it, and it won't even
it's just going to go
be dedicated.
Exactly. I mean, it'd be different if it, maybe had a little plaque or something.
Right.
But no, it won't. And so, that's just really it. Is like, hey, it's which would you prefer? There's two options here. We can do nothing, because you will eventually, I hate to be the bearer of bad news, but everybody will eventually die. And so, these are opportunities for us to make it as, easy and straightforward and inexpensive for your children as possible. A little bit, now goes so much, it grows exponentially. And and
And that's
so
quite a gift. That's quite a gift to give the bereaved, you know, in the event of your passing, to have that be streamlined and have it be written out and simplified. I mean, I can't tell you how huge that is, because you're grieving, you're going, you know, you have a lot to do anyway and a lot of emotions. And to have that all set up is just is amazing.
yeah, I mean, I when people come in, for estate, administration questions and stuff, it's like, well, of course, I wish we would have met under different circumstances, and I know you're, probably still grieving, but this is like kind of the cold, not to be cold or anything, but this is like the business side of it, and it's hard for people to make that transition from grieving to business. So, would you rather have them spend, 6 months with the business side, or, 6 days?
Right.
$3,000 or $300. It's just the streamline. But anything is better than nothing, of course. Especially if you have people that you don't want to include in your estate plan, because if you pass away, and people tell me all the time, I've passed away, brothers and sisters will come in, mom and dad has passed. They say, well, since they didn't have a will, since they didn't have a trust, it's going to go equally to the three, four, or five kids or whatever. And man, they'd be rolling over in their grave if they
Right.
knew
They didn't want that.
son A, or their daughter, or
Yeah.
whoever, was going to get an equal share. Like, they would, like, literally, the law does not give us any discretion. It says it has to go like this way. It doesn't matter if they were cussing them out, if they, whatever. Well, they should have written it down. They should have gotten a will. Should have done something, because they're going to get just as much as you. You could have spent every moment, of their, last years with them. This person hasn't called them in 20 years. Guess
Yeah.
what? They're getting an equal share of the pie. And that's a really heartbreaking conversation to have with people. And it's tough, because the law has zero wiggle room in that front.
Right. And I think, yeah, that's a great point, that, you know, it's having control over where your legacy, at least from a financial aspect, goes. And you want to make sure that it's going where you want it to. And I think I heard on a podcast or something that said, like, if you don't have a plan for your assets when you die, the government certainly does. So
Yeah.
again, you're going to be funding the, you know, whatever.
Yeah.
And it might not be going to who you want it to. So
Yeah,
it,
exactly right.
yeah,
Exactly right.
it's
Yeah.
good to have these things in order. So I'm glad we were able to have this conversation. It's a great starting off point. And I want to thank you for coming on the show and just
Of course.
going over this. I know that's complicated, but I think and I hope that we've been able to just give some general information. If people are looking to begin that process in more specificity and want to connect with you, where can they do that?
Well, Vancouver Wills and Trusts is the name of my firm. So, just start by Googling Vancouver Wills and Trusts, www.vancouverwillsandtrust.com. You can give me a call, 360-326-0134. Me or my staff members, we'll be here to answer your phone call. They're again, because all I do is estate work, they're all very, proficient in this area, where they can answer kind of some of the simpler questions. What should I expect? What would this look like or that look like? But
Sure.
just the first thing is, we offer no cost consultations. And so just come in, hopefully I, am not intimidating to, I try to be as disarming as possible, folks. I'm not like your typical attorney. I'm not wearing a tie, if you can't
Yeah.
tell. So, so, I'm just like, yeah, let's just have a conversation. What do you want to do? How does this want to look? And then, I'll make some suggestions, and then we kind of match it up with, your ideas of, how you want your legacy to look, and then kind of off we go.
All right.
And
Yeah. And just in full disclosure, like, I've used Nick for my own estate planning, and it was super easy to work with him. And it was great. It's a great feeling to have that sort of done, and to have that security and knowing your assets are going to be distributed the way you want them to be. So I thank you for that. I'll have all of Nick's and Vancouver Wills and Trusts information linked down below. If you found any value in this, like and subscribe, and we'll see you next time. Take care.
thank you so much. Bye, Doug.
Bye. See ya.